Hello, my name is Matt King. I'm a privacy manager at the Office of Privacy and Data Protection here at WaTech, and thank you for joining us for this webinar to help us celebrate Privacy Week 2026. We are joined today by Jackie Seitz. She is the Deputy Director of Health Privacy at Legal Action Center, a nonprofit law and policy organization. As part of her duties at the Legal Action Center, she leads privacy advocacy work to protect the confidentiality of stigmatized health data for people in addiction treatment and recovery and people living with HIV. We are very happy to have her here today to help us explore confidentiality protections for people in substance use disorder treatment and how privacy protects civil rights. Jackie, it is all yours.
Okay, thanks. Thank you, Washington, for having me. I'm really pleased to be here today. So I work at Legal Action Center on the next slide, which is a nonprofit. I'm based in New York City, but we work nationally to advocate for the rights of people with arrest and conviction records, people who have used drugs or who are in recovery, and people living with HIV. And privacy, to me, is the flip side of the anti-discrimination protections because a good privacy law can be a great protection against future discrimination or stigma or criminalization on the basis of your health information. And so that brings us to the topic of privacy protections for criminalized health information. So today, I'm just going to cover some of the key features of confidentiality in substance use disorder treatment from my perspective and really focus on why privacy matters when healthcare intersects with the law. This is not going to be a comprehensive training on 42 CFR Part 2 or the recent amendments. I'm happy to answer those questions if we have time at the end, and I can refer you to additional resources. But I want to spend today really talking about why privacy matters and how it works for substance use disorder treatment records. And then I have a lot more resources at the end. So I'd like to start with a poll today to get a sense of the audience. How familiar are you already with the confidentiality protections for people in substance use disorder treatment? A, very familiar, B, somewhat familiar, C, I've heard of them, but not in detail, or D, not at all familiar. And you should see the little poll pop up on your screen. Rhonda, you can close the poll whenever you think we've gotten enough people. And what were the results? Oh, here they are. Okay, so, 4% said very familiar. 31% said somewhat familiar. 38% said I've heard of them, but not in detail. And 28% said not at all familiar. And it's great to see this broad range of familiarity. And I'm not surprised to hear that many people have not heard of this before. Welcome to the topic. There's a lot of confusing and misunderstanding about health privacy laws right now, and they're becoming more and more important in light of sort of an increasing push to criminalize health information. And so I'm really happy to be talking to people with a mix of experiences with confidentiality and substance use disorder treatment. So, why does this matter? From my perspective, which is sort of a mix of a public health and a civil rights perspective. A public health reason why it matters is that it encourages access to treatment and healthcare services. People are more likely to go to substance use disorder treatment if it's confidential. Second, and this is again like a mix of a civil rights and public health perspective, confidentiality improves the quality of treatment and treatment outcomes. So if you feel safe that you can share information with your provider without it being used against you, it's more likely you can share information that ultimately helps with your overall health and recovery. And then finally, this is really the key civil rights perspective. Confidentiality protects people's future against future stigma or discrimination or even criminalization on account of the information that's in their health records. So, to focus for a minute on this access to treatment angle, According to the last national survey that SAMHSA conducted at the national level, 41.4 million people needed substance use disorder treatment in 2023 and didn't get it. When they conducted the survey, they also asked people who perceived that they needed SUD treatment why they didn't get it. And this is some of the answers related to confidentiality and stigma that I pulled out. So 34.8% were worried that the information would not be kept private, and that's why they didn't go to treatment, even though they felt they needed treatment. 43.9% were worried about what other people would think or say if they went to treatment. 18% thought that their family, friends, or religious group would not like it if they went to treatment. And then 33.5% of people didn't go to treatment even though they needed and wanted it because they were worried that if people knew, bad things would happen, like losing their job or their housing or custody of their kids. And so I think that the National Survey of Drug Use and Health really illustrates this first bullet, why confidentiality matters because it encourages access to treatment. But I also want to spend just a minute on the second bullet. Rhonda, could you click? There should be a box that pops up on the click. Beautiful. So the second bullet of improving the quality of treatment and treatment outcomes. Can you use the little Zoom feature to raise your hand if you are a substance use disorder treatment provider or mental health services provider? No hands. Okay, so let me share with you something that I've learned from our colleagues who provide these services. And this is the concept of the therapeutic alliance, which is a great term, but I think is also a sort of intuitive concept, which is that if you think that your provider is on your side, it's more likely that you can share information with them. As I'm sure we've all had contact with someone in our lives or ourselves who have struggled with drug use at some point over the years, right? Drug use is something that affects many of us in the country. And think about the sorts of things that come up when you're struggling with drug use. It's a lot about return to use, cravings, and triggers. Those are sort of key characteristics of the chronic disease of addiction and struggling with problematic drug use. And if you want to talk about return to use, but you're worried that your counselor will use that information against you, you just won't talk about it. And then how will you get better, right? So it really is about maintaining that confidential space to share openly about things that you're going through in the hopes of getting better. And then Rhonda, could you click again? There should be one more animation. And once more. I also want to talk about the civil rights perspective. So we represent many people who have experienced discrimination just in the healthcare system on the basis of past information about information in their health record about past drug use or past substance use disorder treatment, which is to say nothing of criminalization. And people ask me a lot what I mean by criminalization of health data. And I think some of that is fairly obvious, right? If you go to substance use disorder treatment and you have your analysis tests that reveal that you've recently used cocaine, in most states, that's literally illegal, right? That's literally criminalized data that could be used to criminally investigate or prosecute you. And that's especially so if you're pregnant or parenting. And then there's also some not so obvious aspects of substance use disorder treatment records that are subject to criminalization because, unlike, say, treatment for high blood pressure, you may never talk about a history of sex work or a history of domestic violence when you're getting treatment for high blood pressure. But in many types of substance use disorder treatment, basically every aspect of your life is on the table for discussion. And so there can be just a host of other issues that you're sharing for treatment purposes that, in a totally different context, the criminal legal system context, could be used against you, either in a criminal investigation or prosecution, or in even broader ways to revoke probation or parole because people under community supervision have so many additional restrictions placed on the way they move and who they are with and sort of how they live their lives. Okay, so this brings us to the topic of the day, confidentiality of substance use disorder treatment records. There's a federal statute and then the federal regulations. And so I refer to the whole thing as part two because it's part two of Title 42 of the Code of Federal Regulations. And so this federal law strictly protects the confidentiality of patient records at certain types of substance use disorder treatment programs, and these are known as Part 2 programs. The biggest misconception I want to dispel is that Part 2 only applies to records from certain types of programs. It doesn't apply generally to any substance or substance use disorder related information in our healthcare records. It only applies to records that come from these certain type of substance use disorder treatment programs called Part 2. So some common examples of Part 2 programs are opioid treatment programs, otherwise sometimes known as methadone clinics. Another example would be a residential alcohol use disorder treatment program that takes Medicaid, or an outpatient treatment program within a larger nonprofit like a hospital or a CCBHC. The and these are just examples, but I think they're the ones that sort of come up most frequently, where you have a dedicated substance use disorder treatment provider and there's some element that makes them federally assisted. Again, this is the number one topic of confusion about part two, I would say. So here's a simple graphic in case you're interested. In order to be a part two program, you need to meet the definition in the regs of a program. So not all healthcare providers meet that definition. And you need to meet the definition of federally assisted, which means a nonprofit, or you get federal money, or you accept Medicaid and Medicare, or you're federally assisted because you have a license from the DEA to prescribe something like buprenorphine for the treatment of opioid use disorder. So if you're both a program and federally assisted, then you become this Part 2 program where the strict confidentiality protections apply. And then HIPAA is the more widely known healthcare privacy law. So how do these two laws compare? As I just tried to explain, Part 2 is very narrow because it only applies to Part 2 programs and then the downstream recipients who receive records from Part 2 programs. Those are called lawful holders. HIPAA applies basically to all of our healthcare providers in this country, as well as health plans, insurance companies, and another category that I'm not going to talk about. But it applies to almost all healthcare providers, and Part 2 applies so much more specifically to substance use disorder treatment programs. So it's narrower than HIPAA. It has a more dedicated focus of protecting individuals with substance use disorder than HIPAA, which is sort of the general federal floor for health privacy standards. And then Part 2 is generally stricter than HIPAA, including requiring written consent for many uses and disclosures. So Part 2, much more than HIPAA, looks to the patient to see, does the patient want this disclosure of records to happen? And if so, the patient can sign a written consent authorizing the disclosure. HIPAA is much more permissive in letting information flow without a patient's written authorization or an ROI, including whenever there's a disclosure for the purposes of treatment or payment or healthcare operations. HIPAA generally says share it. And Part 2 generally says the patient needs to sign a written consent before you share that information. Another way that Part 2 is much stricter than HIPAA is that the confidentiality protections follow the record. So as I said, Part 2 only applies to records from Part 2 programs, but if I'm the patient and I sign a consent for my records to go to my lawyer, the lawyer needs to also follow Part 2 with respect to those records. If I sign consent and send the records to my health plan, the health plan also needs to follow Part 2 with respect to those records. There were some recent changes that made a number of exceptions to that general rule, but the general rule still exists, and HIPAA doesn't work like that at all. HIPAA just instructs covered entities, the sort of covered healthcare providers, and their contractors to follow HIPAA, but once the health information leaves the HIPAA bubbles, HIPAA no longer applies. And then, perhaps most importantly, Part 2 has very limited exceptions for reporting certain information to law enforcement or the family regulation system. And I have a case study to sort of illustrate how that works in practice. But we're not there yet. So here's a little chart summarizing the way that Part 2 limits disclosures to law enforcement. And this includes federal, state, local, and immigration enforcement officials. So when responding to inquiries, a Part 2 program cannot share any information with any law enforcement official, including immigration. It can't even confirm that like a named individual is a patient unless the law enforcement entity has a special Part 2 court order or written patient consent. Then it prohibits the use of any substance use disorder treatment records against a patient in any type of legal proceeding, unless, again, the patient signs a specific consent or a judge issues a specific Part 2 court order. In Section 2.65, there's very specific criteria for the Part 2 court order if the records will be used to criminally investigate or prosecute a patient, including a requirement that law enforcement needs to be alleging an extremely serious crime. For example, murder. Drug sale, drug possession, drug use are not examples of extremely serious crimes, which makes sense, right? If someone was opening themselves up and going to treatment, and every time they went to treatment, law enforcement was seeking their records to prosecute them for using drugs, what kind of world would we be living in? So there's very specific court order criteria for when those substance use disorder treatment records can be used criminally against a patient. And then lastly, and unfortunately, this one has been coming up more and more lately, Part 2 strictly limits the placement of undercover officers or informants in Part 2 programs. And if a judge authorizes the placement of an undercover officer, none of the information that's gathered can be used to criminally investigate or prosecute a patient, only staff. So if local law enforcement is worried that staff are improperly dispensing drugs or selling drugs or, I don't know, laundering money, whatever the thing is, a judge can authorize placement of undercover officers to investigate staff, but never patients, because the Part 2 program needs to be a place of confidentiality and a healthcare service for patients and not a criminal legal system interface for patients. And now we have our case study, which I named New York City in the 1970s. So you are working at an opioid treatment program in New York City in the 1970s. Your clothes are fabulous, and so is your hair. One day, the police arrive and say they are investigating a murder nearby. They hand you a subpoena for the names and photographs of every Black male patient between the ages of 21 and 35. What are you allowed to share in response to the subpoena? Patient names, but no other information. Patient names, photographs, and any other information that's necessary for the investigation. Only the name of the patient you think was involved, or no patient names, no photographs, and no other information. We didn't set up a poll, so if you just want to put a letter in the chat, I'll just read them very unscientifically. We have 2 Ds. Ooh, we got an A. Good. So far, a lot of Ds. Another A. Nice. D. We got a B. I like to see some variety. Another B. A C. Good. A. All right. I think we have all the answers represented. Allowed to share in 1970 or now? Ask someone. Great question. So the correct answer now is D, no patient information. At the time this happened, Danielle, you're right. In the 1970s, it was sort of a question mark whether this was allowed. And the owner of the OTP in this story famously went to court and argued that he shouldn't have to release any of the information. And the court held him in contempt. He faced jail time. And then through sort of a combination of lawyering and Congress and HHS really strengthening the confidentiality protections, we have the Part 2 protections that we have today, which clearly say a subpoena is never sufficient to release records of substance use disorder treatment covered by Part 2, you always need a special Part 2 court order or the patient's written consent. Now, that's a new change. And think about why this happened. I mean, I named this case study New York City in the 1970s, but I could just have easily have named it North Carolina in 2022, Florida in 2023, New York City in 2024, and maybe Washington in 2025. This still happens every day that police use substance use disorder treatment programs as a fishing ground for finding potential suspects because there still is so much stigma and discrimination against people who use drugs. And think about what that would mean if going to treatment made it more likely that you would end up on a list of suspects in a police investigation, right? Like you can see the problem. And so this case and this smoggy photo of New York City really takes us back there. This case gave rise to the confidentiality protections that we have today. And then here's a nice quote from the regulations themselves, which says, the purpose of the regulation is to ensure that a patient receiving treatment is not made more vulnerable by reason of the availability of their record than an individual with a substance use disorder who does not seek treatment. And the idea here is that going to treatment shouldn't make it more likely that something bad happens to you. If you have kids or you're operating heavy machinery or you're on probation and you're struggling with drug use, it could be bad for the kids or the heavy machinery or the probation. But going to treatment shouldn't make it more likely that you lose custody of your kids or that you lose your job or that you are violated for probation, because then you won't go to treatment, right? Then you'll just try to white knuckle it through or deal with the substance use on your own or hide it. And what we want is for people to feel supported to make that really brave step of asking help for a problematic substance use. And so that's the idea here, that going to treatment shouldn't make it more likely that you get punished for drug use than just struggling with your drug use alone and not dealing with it. And then I have another case study to help illustrate this idea. So Leanna's ex reports her to CPS which is Child Protective Services. Forgot to look up the acronym in Washington. Hopefully it's something similar. So the ex reports her to CPS for neglecting her 18-month-old. As part of the investigation, CPS sends a subpoena to her outpatient alcohol use disorder treatment program. And Leanne is concerned about her program records being shared with CPS, especially her urinalysis results. So again, just put your answer in the chat. How does Part 2 protect Leanna's treatment records? So A, no information can be shared in response to a subpoena unless Leanna signs a consent or CPS gets this special Part 2 court order. B, the program can only share information relevant to the allegation of child neglect. Or C, the program can only share information described by the subpoena, but not additional information. Okay, we have a lot of A's coming in. 1B, a C, B, nice. Okay, so the person who responded C, well, let me start with the correct answer. The correct answer is A. No information can be shared in response to a subpoena unless Leanna signs a consent or CPS gets a Part 2 court order. And I think this case, which is unfortunately based on the story of many people who I've worked with or know, I think this case really gets at the purpose of the regulations. Liana wouldn't have urinalysis tests to worry about if she wasn't in treatment. If she hadn't gone out to get treatment, she would be less vulnerable to the CPS investigation, right? But because she went to treatment and they were doing urinalysis tests for clinical purposes, not for forensic law enforcement purposes, but for clinical purposes, she now has information that makes her more vulnerable to potentially losing custody of her kid. And that's not what treatment is supposed to be about. Treatment is about giving people their health back and sort of helping move them on to a better phase of their life. It's not about punishing them. And so So the correct answer is A, but the people who said B and C I appreciate because those are both very compelling answers. So there is an exception in part two that permits just making certain reports to Child Protective Services if mandated by state law. And so I think it's natural to think like, oh, if CPS is requesting the information, of course we need to share. But the Part 2 exception is so limited that it doesn't apply in this case. Part 2 permits her program to share information with CPS if mandated by state law, if it's related to evidence of abuse or neglect against the child. But no matter what's in those urinalysis results, just using drugs does not necessarily equate abuse and neglect, right? Just using drugs doesn't necessarily equate abuse and neglect. If your kid is with their other parent or their grandmother and you have a safe plan of care for them and you use drugs on your own time, no abuse or neglect has happened. And think about all the privileged people we know in this world who regularly do this, right? But the fact that those urinalysis tests can easily end up being used against someone in a CPS investigation make it so important to protect the confidentiality. And so here there was no evidence of abuse and neglect, so no exception to part two. And then for the people who responded C, basically, yes, give the information response to a subpoena. Again, great answer because you should always respond to a subpoena. You can't be ignoring subpoenas. But what you need to do in this case is you would need to respond to the CPS person who issued the subpoena and say, I received your subpoena. Federal law prohibits me from complying. And so I imagine the people who responded C, that you should give the information as described in the subpoena, are sort of rightly thinking, always follow a subpoena, which is the right thought. It's just that since federal law is more protective and says you cannot release information in response to a subpoena, the answer here is that you can't share the information unless you get consent or special Part 2 court order. And then the last thing that I'll say about this case study is you'll notice that the information can be shared if Leanna signs a consent. And this is really one of the weak points of part two and many of our other privacy laws, which is that if the individual consents, many disclosures or uses of the information can be made, even if it's not in their best interest. And so the reason why this case study is based on a number of more recent cases is because many times when there's an investigation against you by CPS or even your treatment program will say you must sign a consent form authorizing disclosure, or you should sign a consent form because it's evidence of your sort of openness and willingness to engage in treatment. Obviously, as a civil rights lawyer, I don't like that framing at all, but I hear people are getting that advice. And so people are pressured or forced to sign a consent sort of as part of these bigger processes. So I just want to flag the issue with consent in the case study also. Okay, and so for me, these are my sort of hot topic issues with confidentiality that I'd like to leave you with as well. The first one is the one I just flagged about knowing involuntary consent. HHS has said that patients should only be signing consent forms if it's knowing and voluntary. The federal privacy regulations have changed 5 times in the last 8 years. The statutes changed once. They were never simple to explain, and they've only gotten more complicated in my experience as someone who has to explain them a lot. They're only getting more complicated. And so what does it mean for a patient to meaningfully understand the terms of the consent form that they're signing? What does it mean for staff to meaningfully understand the terms of the consent that they're asking patients to sign? I think there's some serious issues with how much people understand when they're signing consents and whether the consents are truly voluntary. The second sort of red flag, hot topic issue for me right now is the downstream privacy protections. As I described, Part 2 is somewhat unique in that its privacy protections follow the records even once they leave the substance use disorder treatment program. But with the recent amendments, there's some confusion and maybe some willful misinterpretation that could be weakening those downstream protections for substance use disorder treatment records. And I think it's something worth thinking about, not just for substance use disorder treatment, but this was a big issue when the Biden administration tried to protect reproductive health information. It will be an issue with gender affirming care records. Our healthcare records are constantly moving in many ways that are basically impossible to anticipate. And so, what does it mean to offer someone confidentiality, but then take it away as soon as the records are shared with someone else? And how do you meaningfully implement downstream privacy protections? And then lastly, this is like new technology, new maybe 15 years ago, but still relatively new. And this is the issue of websites and apps that are targeting people with substance use disorders, either for treatment services or recovery services or something related to treatment and recovery, because our research and others have also shown in research that the websites and apps are potentially collecting tons of information about people that traditional treatment programs wouldn't, like the location data from your phone or a list of all your contacts on your phone. And then, even when a website sort of prominently proclaims that it's 100% confidential, if you, like me, read the privacy notice at the bottom, which why would you? They're horrible. But if you read them, it's actually very unclear what information is confidential, especially information that's collected through the website or through an app. And so the information is potentially being shared with data brokers, which can reshare the information, or with Google or Facebook. And I just don't know that we've made enough progress with substance use disorder and stigma to be opening up all of this sensitive information to be used to create marketing profiles for us on the internet. I don't want that information about me being used for the rest of my life as part of my advertising profile to determine if I'm a good candidate for a bank loan. I just don't think we're there yet. And this has really been an area that has exploded way more quickly than regulations or enforcement have caught up. So these are my three red flag issues. And then we have time for questions. I just have a few more slides after the questions, but if you have any questions, please put them in the chat. I'll keep an eye on the chat in case you want to put anything in. You can also chat to me individually if you want to ask something confidentially, and then I'll just read it out loud without including your name. Here are some resources that we have available, really aimed at substance use disorder treatment programs, which it sounds like is not this audience, but we have a toolkit for programs that are preparing for immigration enforcement that includes sort of a mix of tools, ways to physically set up a space to better protect patients, but also ways that the federal privacy protections for substance use disorder treatment records, ways that those protections also amplify some of the protections for staff and patients. And then we have a letter for responding to law enforcement inquiries. As I said before, programs are, even though we're no longer in 1970s New York City, programs still face tons of inquiries from law enforcement. And so we have a sample letter that lays out the way that the privacy protections apply. We're working on a book on this topic, and we have a number of templates, including consent forms and all sorts of things that help you comply with the law. And you can sign up for updates at our website. I'm very happy to see one question. So, key points. Confidentiality in substance use disorder treatment encourages access to care, it promotes better outcome, and it protects individuals' future. 42 CFR Part 2 is generally more protective than HIPAA, particularly for law enforcement. If that's all you remember, remember this one thing, that there's a heightened federal privacy protection for substance use disorder treatment records, and it is better than HIPAA. And then patient consent and trust are really central to how Part 2 works. But consent can be vulnerable to coercion, and it's important for patients to understand what they're signing. It's important for all of us to understand what we're signing, but it's particularly important when patients are in substance use disorder treatment to understand all these forms they're being asked to sign. Thank you. So I will thank you so much for having me, especially since it sounds like so much of this audience was new to the topic, and it's really a pleasure to talk to new people about it. I will answer the one question.